a legal scholar. I'm not going to get into too much legal detail today, but you'll see I'm going to be referring to a few cases and some issues with respect to rights as well. I'm also an academic visitor in your hero this year, about to move to another institution in Canada. So the question I want to address today is to look at disability, equality, and euthanasia legislation. And so essentially, the main question that I want to address is, how should arguments based on a commitment to the equality of disabled people affect our approach to euthanasia legislation? And I'm not going to entirely answer it, and I'm not going to make really an argument today, but I'm going to look at different kinds of arguments that can be made on disability and equality and how that can relate to euthanasia legislation. And in particular, I want to focus more on one argument, which I don't think we've considered as much. So I think I'm going to look at 3 different arguments, and I think there are 2 that might be quite familiar to people who know about debates, and then there's one perhaps that's a bit less familiar. And I should say that my own background, I haven't done a lot of work on euthanasia specifically. I've done quite a bit of work recently on more the beginning of life, selecting against disability, and including on abortion on the grounds of disability. But I found in the course of my research and looking at arguments with respect to disability equality in that context, that there are some interesting parallels with arguments that can be made in the euthanasia context. So you'll see that I'll be referring to that as well later in my presentation. Okay, so just to start off, maybe this doesn't need to be said, but I'll use the word euthanasia. I'm only going to talk about voluntary, what would be considered to be voluntary euthanasia, and I include assisted suicide and what might be considered to be sometimes called active euthanasia, so both self-administered or administered by a third party or a health professional. I include what's often referred to as assisted dying or medical assistance in dying. I'm not going to refer to cases involving lack of capacity. That could raise important issues about disability, but I'm not going to refer to that. And so as I said, I'm going to focus on some arguments in particular, so I'm not claiming to be comprehensive in terms of all the arguments that can be made in the context of disability and euthanasia. And in particular, it can be complex in terms of the settling on a definition of disability. There are many different definitions of disability, and that could affect the way that we consider disability equality, but I'm just not going to entirely address that or resolve that for my presentation today. Right, so if we think about arguments based on disability equality, largely I'd say there are 2 arguments, and they're often seen as being conflicting with each other, and they're probably relatively familiar to you. And this is not only in the context of disability, it's also just generally in arguments about euthanasia. So this is probably not particularly surprising to you. So on the one hand, we might say that we often talk about a right to die, but that might be more accurately described as maybe a right to assistance to die or a right to euthanasia. Often there's a reference to the importance of autonomy, and that can be contrasted to a right to be protected from euthanasia. So not only to be protected from coercion, but from certain kinds of pressures that can arise, for example, due to vulnerability. That can also be based on a certain interpretation of the value of autonomy. And both of them, I would say, would include a claim for positive action from others. So I think we're well aware of these arguments, right? Is there a right to euthanasia, or is there a right to be protected from euthanasia? Which one is more important to emphasize? So in the well-known Carter case in Canada, which found the prohibition on assisted suicide unconstitutional, the first paragraphs refer to the way that these issues are often presented. It is a crime in Canada to assist another person in ending her own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying, etc. So there are two options. You can choose your own life prematurely, often by violent or dangerous means, or suffer until you die from natural causes. So in the second paragraph, you have, on the one hand stands the autonomy and dignity of a competent adult who seeks death as a response to a grievous and irremediable medical condition. On the other hand stands the sanctity of life and the need to protect the vulnerable. So you could formulate it in different ways, but you could say that for disabled people specifically, you might say something like, so for disabled people, there's an equal opportunity to choose to have access to euthanasia, to choose to have to assistance or to die in a particular manner, or maybe there are especially strong autonomy-based reasons. And then on the other hand, you might say that for disabled people, there are reasons based on equality to have especially strong reasons to be protected based on, among other things, maybe misguided views in the medical profession and in society about quality of life with disabled people and due to higher risks of pressure. So again, here you have two different approaches mentioned in Carter. Some people with disabilities oppose the legalization of assisted dying, arguing that it implicitly devalues their lives and renders them vulnerable to unwanted assistance in dying. Other people with disabilities take the opposite view, arguing that a regime which permits control over the manner of one's death respects rather than threatens their autonomy and dignity. It certainly seems to be the case that some disabled people take one view and some disabled people take the other view. So it certainly seems to be the case that we can't say, disabled people want this. There appear to be different arguments and different views amongst disabled people themselves. But I want to also examine a third kind of argument, which I don't think has received as much attention, and which would be something like this. It would be a right to live without stigma, and the equality would be something about based on the equal moral worth of human beings. So in particular, this argument would be something like that there's a right to live without the law or the state expressing a stigmatizing message that some people, such as disabled people, are singled out as having lives that are less worth saving or less valuable, or some other kind of similar message along those lines. So a few points to note. So the first two arguments, which are quite familiar, require positive action from others. The third does not, I think. The first two arguments maybe follow on from a certain understanding of autonomy and the value of autonomy, so equality linked to autonomy. I think the third does not, or not necessarily. And as I said, I think the third interpretation has received less attention. Okay, so I'm going to go through a few slides on the two first arguments. And again, I assume that there are many different slides I could have put, and that the general idea is probably quite well known to those who know about debates on euthanasia. So, for example, there's here's some excerpts from an article, Death in Our Life, written by Joseph Raz. He refers to a right to euthanasia. It refers to the importance of the capacity for rational agency. So the capacity for rational agency It's the basis of a duty to respect those who have it. It extends to the way people live their lives, includes to determine when and how to end one's life. Having that option is valuable, and therefore it is protected by what he calls the right to euthanasia. The right to euthanasia grants each person the power to choose themselves the time and manner of their death. So it's quite a reflection of a sort of liberal approach to values in life, that you can choose how to live your life, you can make plans, you can make your own plans, and that making a plan for your death is part of your life. That's part of the important decision making that you make for your life plans, right? So those who reflect, plan, and decide on the manner of their dying make their dying part of their life. And if they do so well, then by integrating their dying into their life, they enrich their life. So there's a lot of rights talk with respect to euthanasia. So sometimes there's a reference to a right to die or right to euthanasia. The right to life might seem to be in conflict, but not necessarily. So interestingly, you could think that in some contexts, the right to having assistance in dying can be interpreted out of a right to life. And there's something said to that extent in Carter. So if someone has a condition, meaning that at some point they think that they're no longer going to be able to take their own life, they might say they have to take their own life earlier, and therefore they're losing weeks or months or a certain period of time that they could otherwise live if they were able to have assistance. And so that not having the right to euthanasia, in fact, reduces the lifespan and negatively affects the right to life. So the right to life and the right to die are often seen as in opposition, but they don't necessarily have to be seen that way. So with respect to the right to euthanasia and disability, so in the example I just gave, you could see how that could particularly be an argument that can be relevant for disabled people. If it was a disability, that might mean that eventually someone wouldn't be able to take their own life. There could be a claim to right to euthanasia out of the right to life. The right to life is protected in a number of important rights instruments, so including in Canada in these cases and in other places. So it's often included in the rights instrument at issue. So on disability here in a subsequent Canadian case, so in it, there are a number of different developments in the Canadian context. At one point, it was possible to have what they call medical assistance in dying if death was reasonably foreseeable. But in a decision in 2019, it was found that limitation was unconstitutional. So here, with respect to disability, so one concern about that is that it would raise particular risks for disabled people. So the court in that case said it fully understands the warnings regarding the potential danger related to the social normalization of MAID and possible suicidal perception of people with disabilities. However, the court cannot disregard the fact that disabled persons may have a rational and legitimate desire to end their lives, but also and especially because of the enduring and intolerable suffering they're experiencing, which is interesting, especially disabled people. Okay, so by contrast, there might be a right to be protected from suicide or a right to be protected from euthanasia. So the kinds of arguments that are raised refer to risks of pressure, vulnerability, fear of being a burden, financial constraints, lack of access to health and social care. So I'm still considering that we're talking about voluntary euthanasia, but the argument here is it might be a constrained choice where someone might prefer to have better health and social care, and so is making a somewhat voluntary but constrained choice to have euthanasia instead. So this argument can still be based on the value of autonomy, but it could be based on the idea that there needs to be a richer form of autonomy with fuller options. And reference could be made, for example, to literature on relational autonomy put forward by a number of feminist authors that point to the fact, so the idea is generally that to be fully autonomous, you also have to look at some societal and social constraints that can limit individual autonomy. So there's one article written on, so again, the Canadian context. You'll see why I refer to the Canadian context, because it's a singling out of disability. So it was argued, for example, by Professor Beaudry that something you can call somatic oppression can affect someone's autonomy in the context of MAID, which would include having attitudes based on ableism, ageism, diseaseism, and that can affect the way that someone sees their body and sees themselves. So here's another example that Professor Tom Shakespeare, maybe some people have heard of him, gave some testimony in that Canadian case. So Professor Shakespeare mentions how disabled persons can experience a double disability, the disability that affects them physically, and also the other, which is social, being imposed on them by society, organization, and attitude. So it's essential in his view to have a societal model that affirms the inherent value of their lives, their equality, and their contribution to society. And this does not reinforce negative stereotypes in that regard. And I won't read all of this out, but it's well known in the disability literature. People refer to the disability paradox and also to the importance of adaptation. So the disability paradox essentially is the idea that people who aren't disabled have a more negative view of the quality of life of disabled people than disabled people have themselves, who normally report a good or excellent quality of life or a better quality of life than others would imagine. So there's this disconnect in understanding what life with disability really is like. And a lot of people in the disability literature also refer to the importance of adaptation. So if someone becomes disabled or has a serious illness, there could be a very difficult period initially to adapt to it. But literature suggests that many people can, over time, often adapt very well, and again, better than what other people would often assume. And so that also is important to take into account. So even if you have, say, a particular desire or wish that's expressed by someone, maybe who's just had a certain diagnosis, a change in their medical condition, it might be that they're going through a period of adaptation. It might be that they could have different views over time, and it might be that their own view of their disability can be affected by the views of other people in a way that misunderstands disability. Right, so here's a kind of equality-based argument. Isabel Grant is a professor of law in Canada. So she said, it's very important to give people with disabilities more choices and more autonomy in how they live their lives, but offering autonomy over death to those who may not have access to what they need to live does not enhance equality or autonomy. It simply provides an exit ramp from the state-sanctioned misery of their lives, an exit ramp that will save the state millions of dollars in healthcare and social supports. So there might be an argument that if we say that there's some value in the autonomous choice to have recourse to euthanasia, if you really want to value autonomy, then you have to look at what the other options are and whether there are this, sufficient social supports as well that can be chosen. Right, so I also thought I would include a few more excerpts by Raz, because I think he addresses quite an interesting point here with respect to pressure. So it's often thought that there can be a risk if euthanasia is allowed, that people might feel pressure to have it, or that they might decide they want it because they're worried that they're going to be a burden. And that's often presented as a reason for that against allowing euthanasia, or thinking about particular safeguards. And it's often thought that that's not the reason that we want people to have. We don't want people to have euthanasia because they're afraid of being a burden, or because society thinks that they're too expensive. But so it's interesting how Raz presents it here. So he refers to these kinds of considerations here. He says if someone is making a decision, they might consider how their decision will affect other people, sparing others effort and distress, preventing one's savings from being used up on medical and other forms of care, saving public expense, preventing the memory of others, of yourself as a person in decline. And he says, clearly improper pressure may be applied with a view to taking advantage of people's fragility, but what constitutes improper pressure depends in part on whether these considerations are appropriate in the first place. I see no reason to think that they are not. So a counter-argument to the right to be protected from euthanasia might be that that it's rational and proper to be taking into account whether or not you want to be a burden on other people, and that's not a reason that we would necessarily want to discount from people's decision making. He says, now it seems to me that if public bodies are right in limiting the resources to be spent on keeping me alive, I should acknowledge that their decision is right, and in appropriate circumstances I should apply similar standards in deciding for myself how much others should sacrifice in order to keep me alive. Right, okay, so the third argument I want to examine on disability equality is what might be called a right to live without stigma. And so the question is there a negative effect on disability equality through singling out disability as a ground for euthanasia in the law, which would send a stigmatizing message about disabled people? So I'm going to say a few things about stigma first before coming back to that argument. So stigma is related to some other concepts like prejudice or stereotyping, negative stereotyping, but it could also, according to certain definitions, be singled out as a different kind of harm. Stigma comes from the same Greek words as in the sense to pierce or to stick. It's associated with the idea of a mark that distinguishes someone from others and that's publicly recognizable. For the Greeks, there were actual physical signs, so signs that were cut or burnt into the body to indicate that someone, there was something wrong about someone, or someone was dangerous, blemished, polluted, or of lower moral status. An influential understanding of stigma is presented by Bruce Link and Joe Fellon. So they refer to a number of different elements. So first of all, distinguishing and labeling human differences. Secondly, associating that with negative stereotypes. Thirdly, creating a distinction between us and them. Fourthly, having, because of that, status loss, discrimination, and unequal outcomes. And that also has to be understood in the context of a certain kind of power dynamic and the exercise of political power. So stigma is not just about having a negative attitude, it's supported by the state. It's public and it's state supported, and it's an unequal misuse of power. So here's another quote. So traditionally, discrimination focuses on individual harm. So stigma, you could understand it as, if you're looking at the problem of stigma, it's not an individual problem. It's by definition a problem with society. We could also understand stigma as being related to human dignity and being a kind of dignitary harm. So human dignity is notoriously hard to define. We might think that you can understand it through specific concepts like stereotyping, prejudice, stigma. Sandra Fredman here in Oxford has presented that view. And myself and another author, in a piece we wrote on stigma, we suggest that maybe stigma has the claim to be the most harmful. It seems to go beyond stereotyping and prejudice to be the most harmful, so possibly the most harmful form of dignitary harm. Right, okay, so here is some legislation. Here are some provisions of Canada's criminal code. So in particular, a person may receive MAID only if they meet all of the following criteria. And C mentions they have a grievous and irremediable medical condition. And then in the next subsection, we have the definition of grievous and irremediable medical condition. Only if they meet all of the following criteria: they have a serious and incurable illness, disease, or disability. They are in an advanced state of irreversible decline capability, and that causes them enduring physical or psychological suffering that is intolerable to them and that cannot be relieved under conditions that they consider acceptable. So I'm going to focus a bit on the Canadian example because there are there's different legislation on euthanasia. Canada's received a lot of attention, but with respect to disability, it is interesting because there's a specific mention of disability in the law. Right, so Isabel Grant talks about how disability organizations have criticized this and says the law violates the rights of disabled Canadians by devaluing them and stigmatizing their lives, and that's singling out the suffering associated with disability in a way that portrays it as different from all other forms of human suffering, and as the only suffering that warrants death as a solution. Is based on an ableist stereotype that life with a disability may be worse than death. So you see the reference to stereotype and stigma, but there is stereotyping, but you might say because it's in the law and it's state supported, it's stigma, especially. So this is one way of understanding it. So again, Professor Grant says, criminal law plays an important expressive function in messaging what behavior is acceptable in society and what behavior is condemned. By allowing medical professionals to provide death to people with disabilities, the code sends the message that these disabled lives are less worthy of saving through suicide prevention efforts than the lives of those without disabilities. The expressive role of this legislation goes well beyond those who actually access MAID. The legislation risks normalizing death as a response to the suffering associated with disability, which is stigmatizing for all people with disabilities. Some similar kind of language comments by Tom Shakespeare in one of the cases. So I just wanted to point out again that the importance of sending a message, the expressive function of the law, and the stigma associated with the message. So he says that could be receiving the implicit message that they would be better off dead. So the critique is not really just that it's possible to have euthanasia if you're disabled. The critique is that disability is specifically singled out, and not every kind of reason based, for example, on intolerable suffering would allow access to MAID. So Isabel Grant mentions, for example, what if someone suffers intolerably? They consider they suffer intolerably because of something like intergenerational trauma of residential schools, which receives a lot of attention in Canada, or a long history of sexual violence victimization. So you have a singling out of disability, which is associated with the idea that it can cause intolerable suffering. But there are other kinds of reasons which we might think could cause intolerable suffering, but that are not included within the legislation. Okay, well, so I'm going to make a comparison now with some developments on abortion on the grounds of disability, because very similar arguments were made in that context, and where there was, so a few years ago in 2022, in the Court of Appeal here in this country, there was a challenge that raised very similar kinds of ideas that I've discussed in the context of euthanasia legislation. So in this case, Crowther, there was a challenge based on the idea that the abortion ground in the law on the disability ground in the law on abortion expresses a negative message about disabled people. And that this negative message interferes with some of their rights under the European Convention on Human Rights. I'm not going to go through all the detailed legal arguments, but in the Canadian context and in this context too, it's relevant as well to look at how those particular rights under the Canadian Charter or under the ECHR can be interpreted. And I won't go into detail, but these are arguments that aren't just about a moral right or about ethics, but that are made with respect to an interpretation of rights in legal rights, human rights. So the argument can be understood. It's based on the fact that the law singles out disability. It's not an anti-abortion argument. It would not require restricting access to abortion. It wouldn't require restricting access to abortion on the grounds of disability. The argument can be understood as being based on the fact that the law explicitly singles out a ground based on disability, and also perhaps that it gives increased access to abortion based on that ground. So the disability ground in the law on abortion is the only ground that's based on the future child's characteristics. The other grounds are based on a health risk, and that ground is available until birth, whereas the vast majority of abortions have a time limit of 24 weeks. That was an argument made in the law, but some of you might be familiar with the expressist argument in the bioethics literature. So for many years, there's been an argument that prenatal testing and selecting against disability, or those practices, express a negative message about disabled people. And there are various permutations of that argument, and there are counter arguments to it, but that's a well-known argument in the bioethics literature. So interestingly, in the Crowther case, that argument that has been in the bioethics literature for a long time essentially came to court and was presented as an argument with respect to legal rights. So again, I won't go into detail in the rights analysis, but they referred in particular to Article 8 in the ECHR, which is a right to respect for private and family life. And there's a case from the European Court of Human Rights that interprets Article 8 as saying that Article 8 can embrace multiple aspects of the person's physical and social identity, in particular, any negative stereotyping of a group when it reaches a certain level is capable of impacting on that group's sense of identity and the feelings of self-worth and self-confidence of members of the group. It is in that sense that it can be said as affecting the private life of members of the group. So the argument is that the negative message in the law, not the substantive operation of the law, but the negative message it interferes with Article 8 and can affect people's feelings of self-worth and self-confidence. It's not an argument about the fetus. It's an argument about existing born disabled people who are being stereotyped. Right. So the appellants were not successful in Crowther. So I should say they weren't successful in their challenge to the disability ground. Although I don't find the central reason that was given by the court to be particularly convincing. The Lord Justice Underhill essentially said that he thought that the provision was not concerned with disabled people, but with fetuses, with the unborn. Right, so imagine that your law on abortion says the following. Imagine it says there are two grounds for abortion. One is there's a health risk to the woman. The other is if you're expecting a girl. Would you say that sends a negative message about women and girls? Or is that just autonomy? Okay, so let's say your law on abortion has two grounds. It only says you can have an abortion if there's a health risk or if your child will have a particular ethnicity. Does that send a negative message about people who have that ethnicity? I think yes. So, I think yes. Right. So if you had euthanasia legislation that singled out a particular group that said, oh, we are especially going to give euthanasia access to people from this ethnic group, is that stigmatizing? Yes. Should that engage a fundamental human right? Yes. Yes. Right? Okay, so I've written a lot about that case, but so essentially I think there are strong reasons to say that the disability ground in abortion law does send a negative message. It's a message from the state. It's in a statute. It's about whether a future person will live. It raises concerns about eugenics. It's not a pro-life argument. So if abortion was allowed for any reason, you wouldn't have the singling out. So if you had complete decriminalization, you wouldn't have this problem. So if you said abortion was allowed for any reason or any reason until a point in time, you wouldn't have this problem. So it's not a pro-life argument. The problem is in the singling out, in saying there are especially good reasons to have abortion based on this characteristic, which is not that different from saying there are especially good reasons to end your life based on this characteristic. I don't think it's too expansive an interpretation, and I think it's actually quite important that you could construct a right to live without stigma out of fundamental human rights. The ECHR came out after the Second World War, where Europe said never again. And a lot of the horrors of the Second World War didn't come overnight. They came after mass stigmatization, right? Us and them, you are different. You are not like the others. It started with a lot of the harms that we think about started with stigma. Okay, now maybe we can distinguish some of what I've said about abortion on the grounds of disability with euthanasia legislation. So I'll consider now, I'll come back to euthanasia now and think about what message we might consider could be sent through the legislation in that context. So we might say, first of all, okay, it's different because of choice, right? So abortion, you're making a different decision about someone else, about the fetus, and in euthanasia, hopefully it's a voluntary choice. It's based on your autonomy. So it's different. I see the point, but we're talking about the message in the law. We're not talking about, do you want this or not? We're saying the law is telling you this is an especially important reason. There's some overlap with the stigma argument and the second argument I considered, because we might think that it's potentially a constrained choice. And as I said before, if we're emphasizing the importance of choice, you have to ask, why is the law saying that this particular choice, this particular reason is particularly important? Can we make a distinction based on state intention? So something that's sometimes said in both the context of abortion and euthanasia is there a concern about costs? Are we hoping that there's prenatal selection to save costs for society? That might raise fears of eugenics. Are we hoping that people are going to end their lives early to save costs for society? So that raises, you'd have to look at other kind of factors maybe than the law itself in order to determine the state's intention. I think that's an interesting point to think about. In the Canadian context with the Carter case, if you just look at how the changes were brought in through a court decision initially, it doesn't seem like that was motivated by a desire to cut costs. It seemed like it was motivated by an interpretation of rights under the Charter, although now there is definitely discussion in the Canadian context about whether costs are playing an issue or not, and the provision of MAID and the provision of other health and social care. As I've written a book that's coming out where I talk about intention in great detail, if ever you want to look at that. So one important distinction that could be made might be, so you might have, depending on the legislation, with euthanasia legislation, it might be only allowing euthanasia in cases where there's a reasonable foreseeability of death or within a particular time frame. So if you have, say, 6 months left to live. So you might say, okay, well, there you're not singling out disability, and maybe there isn't a kind of message if you're limiting it based on a time based limitation. Or at least the message is less strong, or if there is some kind of message being expressed, it's not specifically about disability. I think there's certainly something to be said for that. Again, there is a parallel with some discussions recently on abortion on the grounds of a short life expectancy. And so we might ask again some questions as to what kind of message is being expressed if we think that there are especially strong reasons to allow abortion based on a limited life expectancy. So it's often thought that there are especially strong reasons, but I think it's actually not obvious to articulate what those reasons are. And there could be a concern. There could be a concern that if the law gives stronger, reflects stronger reasons to have abortion based on a limited life expectancy, it's reflecting the view that that the infant with a short life expectancy maybe isn't a full person or has a different form of lower personhood. Maybe that doesn't apply at the end of life. Maybe we think it's different, that the infant will only live for a certain period of time and no longer is different than having an adult with full capacity who's lived their life up to a certain point in time. Maybe we don't think that the same kinds of issues regarding personhood arise in the context of euthanasia. So if we are concerned with potential stigmatizing messages, we might think, what would be the different effects in different kinds of legislation, right? So we might think that if you have disability specifically mentioned, it might send a negative message about disabled people. If you listed very specific disabilities, then you might then not send a message about those disabled people who didn't have those particular listed disabilities, but then there would probably be a higher risk of stigmatizing specifically those with the name disabilities. And as I said, if you said that euthanasia is only allowed, say, for terminally ill adults with 6 months or less to live, well, I'd be interested in hearing your thoughts. So there's probably less of a concern of stigma in that case. And it's not the same issues that arrive for disabled people more generally. But there still is some singling out inevitably. So maybe we think, oh, it doesn't really matter. We want to give that group autonomy. But at the same time, there is still a singling out. So you are still creating a kind of us and them sort of category, right? Maybe we think, oh, well, it doesn't really matter because if you have a limited period of time to live, even if it is stigmatizing, it's only for a few months, it doesn't matter. I don't know. But I mean, I think maybe the stigma isn't as strong, but I think we have to accept that there is still that sort of same process that can operate even with that limitation. So just a reminder, I think if I compare again with the law on abortion, you can there avoid the stigmatization critique. Because as I said, if you had a liberal law on abortion, you wouldn't be singling out disability. In practice, abortions could happen on the grounds of disability or for other reasons, but the law wouldn't be singling it out. So you could have in practice abortion on the grounds of disability, but not the law singling it out. So you wouldn't have the law expressing a negative message. But with euthanasia, I think maybe we need to accept that if we generally have a commitment to general suicide prevention and an idea that there have to be safeguards, it seems like you're inevitably, at least to some extent, going to have to face the issue of singling out and stigma. Even though some forms of stigma might be worse than others, there will be some singling out. Okay, so these are my final thoughts. So I wanted to say that there's more than one argument that can be made about disability equality and euthanasia legislation. The first two are very well known, and it's not true that all disabled people have the same view. There are different arguments that can be made pro and against, essentially. The different arguments can conflict with one another. But I wanted to draw attention in particular to the argument based on stigma, which hasn't received, I think, very much consideration, but I think it's an important one that also needs to be considered maybe further. And I haven't talked in today so much about the detailed interpretation of rights, but so certainly if you're looking at the context, say in this jurisdiction with the European Convention on Human Rights, there are strong arguments to say that you have case law from the European Court of Human Rights that is concerned with stigma and with stigmatizing messages. So this is not just an argument about morality or ethics, but there are particular legal implications. And I think if we're considering this more in the future, we might want to think more about when we're making arguments about equality and about rights, what rights are we talking about? Are we talking about something which is really a fundamental human right or not? What kind of rights-based interpretation are we making? And if there are different arguments that can be made, is one stronger than another? So as I said, I'm not going to give you my full argument. You probably have noticed that I've tended in a particular direction, but the first two arguments which we hear of very often are based on autonomy, and they require positive action from other people. Stigma, I think, does not require positive action from other people, does not necessarily depend on autonomy, is more clearly tied to the idea of equality in terms of moral worth of human beings, and is arguably the most important in terms of thinking of human dignity. So there are at least reasons to think particularly of this third interpretation of the relevance of disability equality to euthanasia legislation. And then I'll stop there.